Good evening, everyone. My name is Leah Silver, and I'm very excited to be a part of this evening. During the day, I am counsel at Airden Burles in the real estate department, and in my spare time, I'm a proud trustee at the Jewish Foundation of Greater Toronto. I'm pleased to welcome everyone tonight to the second session of the Jewish Foundation and UJA Women's Philanthropy's Financial Literacy Series. As you know, tonight we will be covering estate and family tax planning. Before we begin, I would like to thank our generous webinar sponsors this evening. Thank you to Airden Burles, Baskin Wealth Management, BMO Financial Group, and Crow Soberman. We are very grateful for your continuous support. Thank you. Now, please allow me to give you a very quick update on what's happening at the Jewish Foundation, as well as UJA's emergency campaign for community resilience. Obviously, right now, the biggest concern facing our community is the effect of the pandemic on our most vulnerable members. In mid-March, UJA launched the emergency campaign for community resilience to support our Jewish social service agencies and their surge in requests for help. There was also concern that the economic hardships would lead to major withdrawals from Jewish experiences, especially for youth attending Jewish schools and Jewish camps. As of today, over 10,800 community members have contributed to the projected community needs. We are in awe by how quickly this community came together. However, there is still a way to go. We've made incredible progress, but we still have $13 million more to go to meet the projected needs of our community. In this exceptionally difficult year, more than ever, every dollar counts. If you have already made a gift, thank you for your support. If you would still like to participate or are interested in learning about opportunities available in women's philanthropy, please contact Rachel Wolfson at UJA directly, or find out more, please visit the website jewishtoronto.com. Many people do not know that the Jewish Foundation is one of the largest community foundations in Canada, with over 2,200 funds and planned gifts comprising over $660 million in assets and expectancies. The foundation makes charitable giving easy and rewarding. It allows individuals and families to fulfill their personal philanthropic goals and translate their charitable vision into impactful solutions for some of our community's most pressing challenges. Over and above the annual campaign, a fund with the foundation can really help you connect to the organization and projects that you are passionate about. If you're interested in opening a donor-advised fund, leaving a legacy with the foundation, or simply beginning to think about your philanthropic journey, please reach out to Brett Henry at the Jewish Foundation. You can also reach out to the co-chairs of this evening's webinars, who are both long-standing active members of the Foundation's Professional Advisory Committee, and would be more than happy to answer any questions you may have. Speaking of our co-chairs, it is my honor to introduce tonight's co-chairs and panelists, Ali Spinner and Marni Pernica. Ali is a tax partner at Crow Soberman and is on the Foundation's Board of Trustees. Marni is a partner at Airden Burles. Both are very active and dedicated leaders within the Foundation.
Thank you, Leah, for the introduction. I'm Ali Spinner. Being a part of the Jewish Foundation has been very rewarding for both Marni and myself, and we are so happy to be the panelists for this evening's webinar.
Hi, I'm Marni Pernica. I'm very pleased to be here with you tonight, and I'm also pleased to introduce our moderator for this evening, Mickey Nachmani. Mickey is Vice President of Business Development and an Associate Portfolio Manager at Baskin Wealth Management. Thank you so much for moderating us tonight, Mickey. Best of luck.
Thank you very much, Marni and Ali. Welcome again, everyone, to our webinar. We have so many attendees this evening, and I'm happy to see this is the most interesting event for all the community. Thank you for joining us. Remember, if you have any questions for Marni or for Ali during tonight's discussion, please use the chat function. And please note that our official webinar will run until approximately 9 p.m. But Ali and Marni have graciously agreed to stay on the webinar to continue to answer any question beyond this time. So we would like to start, as it's such an interesting story and topic for so many people, we would like to start with a poll. So you will see in a minute a poll on your screen, and we will be happy if you can respond to it. It's anonymous, and we want to see do you have a will, and do you own assets jointly with your children to avoid any probate? Please answer the questions, and we will join the response in a few minutes as they come in. So Marni, let's start with you. So why does someone need to worry about a will? Why does it matter? Should someone be in a certain age and state in life before acting and starting a will?
So great question, and what a way to start off tonight. So let's start with first principles. What happens if you don't have a will? And I think that's something that people really need to understand. And in Ontario, we have what we call the intestacy rules. And to the extent, one of the fears that everyone has is that their money is going to go to the government. But I can tell you that the intestacy laws in Ontario will kick in to distribute your assets along a table of consanguinity, is what we call it. So the first kind of concept is, well, if you don't want the government to decide how your assets go, having a will is important because the scheme of division is quite significant. One thing I'll point out about intestacy laws in Ontario is that they currently don't cover common law spouses. So to the extent you pass away and you're in a common law relationship and you're not married, your spouse will have no entitlement to your estate. So that's kind of the first concept. The second concept that I like to stress with people, and this kind of rings true a lot for younger families in particular, is if you are married and you have children, contrary to what you may think, the law won't say give everything to my spouse. Instead, we have what we call a preferential share, currently set at $200,000. So the first $200,000 will go to your spouse, and the rest will get divided between your spouse and your children, depending on the numbers of kids. It's a bit of a different division scheme. And the last point I'll make on that is, to the extent your children are minors, that money will get paid into court. The office of the children's lawyer will step in to manage their inheritance, and they will get it at 18. So to me, not having a will once you have kids is catastrophic. And I'll add that, oftentimes young families are like, well, I have nothing to give my kids anyways, but I find a lot of them have life insurance. And so I would just be cautious about the fact that if you've got some life insurance, you don't want it being paid into court or your kids getting it at 18. So and that's Marni, yep.
I was going to say, what people may not realize is that it's not a choice. It's not like the surviving spouse has the option of managing that money for the kids until they turn 18. They cannot. So no matter how hard you try, the surviving spouse is going to be in partnership with the public guardian and trustee or the office of the children's lawyer to manage that money. It's someone else deals with it. So it's a huge hassle.
And they get it at 18, which is not ideal. So that's kind of my first, you have kids, I think at that point in time, it's essential. Another reason why is, to choose how you distribute it, to choose the terms under which you distribute it, to choose who's in charge of how you distribute it, for younger families to help give guidance about a guardian for your children, and to make sure, because you can do that appointment in the will. So that's there's just a couple of reasons why I think it's critical. Probate fees, we're going to get into probate fees without a will. You've got some big probate fees and potentially income tax that you could have minimized on death. There's just a couple reasons.
Okay, so I just want to mention before we move on to the second question that all the questions should be at the Q&A section and not on the chat, so we will be able to respond to them as they come along. So I wanted to follow up with another question, Marni, for you. How often should someone review their will and consider making changes to it? Is it important every few years, every age differences?
So my general rule of thumb and what we tell clients is every 5 years, at least, you should be turning your mind to the document, asking yourself the question, has something changed? What does it say? Have my kids turned a certain age where I think it's time for them to change. And, sometimes you can just give your lawyer a call and say, look, it's been 5 years. Have there been any changes in the law that I need to know about? Because this area recently is really undergoing a lot of change and becoming a bit more sophisticated. So every 5 years to me is the outside when you should be looking at it. Other common times where we, we'll give our clients a list of things that they should consider: marriage, divorce, an inheritance, receiving a windfall, a huge change in your financial circumstances, whether positive or negative. Those are generally, accident, disability, starting to take care of a loved one that you are now helping both financially and on a personal level. Change in life circumstance. Whichever occurs first, give your lawyer a call.
Okay, good answer. Thank you. But, talking about lawyers, everyone obviously is talking about, can someone do do you have to go to an expensive lawyer, or can you make a handwriting with your will yourself? Like, how important is it to do it with a lawyer and not just by yourself?
So I'm a big believer in going to a professional and going not only to a lawyer, but going to a lawyer who specializes in this area. As we're going to see over the next hour, this area is quite nuanced. It touches on family law, income tax, Ontario tax, real estate, corporate law. To do it properly, you've got to have a lot of knowledge in a lot of different areas. Now, with that said, do you have to go to a downtown firm to get it done? Not necessarily. There's lots of sole practitioners who specialize in the area. So my general rule of thumb is go to someone who specializes in it, get the advice, spend a bit of money on it in the first instance, because spending the money is going to save a lot of money in the long run, either through tax savings, through no litigation, having a proper plan. So I'm a big proponent, go to someone who specializes and find someone who works for you in the relationship. Because when I'm with my clients, I say, this is one of the, if I'm doing my job correctly, this is one of the most personal conversations you're going to have with someone. So really take the time to make sure you enjoy the person you're working with. And hopefully this is a lifelong relationship.
Marni, what would you expect? I'm sure I can see some questions coming in. What would you expect the range in the cost of a will to be? And I know it's a sky's the limit, but take a basic will for an example. What should someone expect to pay?
Sorry, for what?
For a basic will, what would you expect somebody to pay?
So basic is a great question, but to me, a comprehensive plan for anyone, call it, single. I generally say, husband and wife. We do powers of attorneys for property and personal care, and we can talk about what those are later. Throw in a spousal trust for the kids, or a spousal trust for the kids. Generally speaking, a sole practitioner is going to charge, I would guess, in the $1,500 range. Wills can go up to $10,000, $15,000. To the extent you're doing probate planning, primary, secondary wills, if you have shares in a private company, again, we'll get into it later. That range, even with someone who specializes in it, is going to be in the $2,500 to $3,500 range to be done properly.
Okay, so I have a question for you, Ali, now. What taxes have to be paid when someone dies? Are there more than one type of tax that comes into play on that, or is just a regular tax paid?
Mickey, that's a great question. And there's actually a number of different taxes. It a little bit depends on the type of assets that you own. But so number one, we often talk about the little tax and the big tax. I'll get to the big tax first. The big tax is effectively the Canadian income tax. And in Canada, we have a system where during your lifetime, you don't pay income tax on the appreciation within your assets until you either sell them or if you die. And I should add, if you die and you leave your assets to your spouse, there's a rollover to your spouse. It's not a taxable event if you leave them to your spouse. So effectively, if you pass away and you leave them down a generation or to a friend or to a charity, there will be tax at that point in time on the appreciation, on the growth, not the absolute value, but the increase in from what you paid for it to what it's worth today. And of course, in Ontario, for example, our current, I say current, there's lots of talk about potential changes, who knows? Our current tax rate on gains is about 27% tax. And the current tax rate on, for example, whatever's left over in a registered a RIF or an RSP, the current tax rate would be 53.5% tax. Those are the big numbers of what comes in on death. The little tax that we talk about is probate or estate administration tax. And that is tax, and don't worry, we will talk about some ways to avoid estate administration tax, but estate administration tax is I liken it to almost, it's like a stamping fee that the court charges effectively to probate the will, and Marni, you can correct me if I use the wrong term, but certify the authenticity and appoint an estate trustee to the will to allow the will to be processed, if you will. That's required by certain institutions or for certain assets. And the fee charged, it's really not a tax, it's a fee. The fee charged is effectively 1.5% of the value of assets. There's a sliding scale at the beginning. I basically tell clients it's $15,000 for every million. So of course, if you've got a modest estate, it's a modest amount of probate fees. But if you own a $100 million rental property in the city of Toronto, which isn't terribly unusual, that could be, $1.5 million of probate fees or estate administration tax on top. Now, of course, in addition to the income taxes, the probate fees, there's also other taxes. One big example, we'll talk a bit about it, are US estate taxes. The reason I'm bringing it up is not that I'm a US tax practitioner. I'm not an American CPA. I am familiar with some of the rules. And at a very high level, the thing to keep in mind is that as Canadians, so even if you're not, I'm not talking specifically to the American citizen. If you're an American citizen or green card holder, you've got other issues, I'm teasing, but the taxes could even be higher. But to a Canadian, a plain vanilla Canadian, not an American citizen, if you die owning what's called US situs assets, including stock, the biggest one, the one that we see the most often is having a personally held stock portfolio of American companies. It includes American real estate. If you have a motor vehicle or a boat in the States, I won't get into some of the more exotic things, but effectively, if you have American real estate or American stocks in your personal name, if you are worth, you as an individual person, if you are worth more than approximately 11 million US dollars, or you and your spouse more than 22 million US dollars, your US or a portion of your US assets, that American stock portfolio that we just talked about, may be subject to tax at a rate of up to 40%. So it's a huge tax. It's based on asset value, not gain. It is very important because we see lots of people who are worth more than 11 million US dollars personally, or 22 million as a couple. That's the approximate number, and do have these American assets. It's, you've got shares of Pfizer, not Pfizer Total Landscaping, but you got shares of Pfizer, you got shares of Google, whatever it is that you have. You don't want to be paying 40% of that to the IRS on top of the income taxes and all the other taxes you have to pay. There is some planning that you can do. And the reason I'm bringing it up as well, and this is something that Marni and I deal with every day in our practices, there's a lot of talk in the States, especially with the Biden administration coming in, that the US estate tax exemption, that $11 million number we talked about, there is a sunset clause. The 11 million used to be 5 million. It's going to go back to 5 million. I don't want to throw too many numbers at you. The bottom line is, if you are wealthy, if you're significantly wealthy and you have American assets, you have to consider how you hold those American assets, or you may face a 40% tax payable to the IRS on your death. So those are the different income taxes, probate fees, American taxes, could be other. Sometimes you end up with land transfer taxes trying to move property around, but I'll cut it off there.
Okay, we have a more specific questions about the US side in a minute, but I want to refer to Marni again. I want to talk to you or ask you about dual will. Dual wills, I think Ali mentioned that before. So we have a primary will and a secondary will that can be used for probate planning in Ontario. Can you please elaborate what it means?
Of course I can. It's like 90% of what I do. But just a couple of things I just wanted to add to what Ali said, just as I saw some questions coming in. When you're calculating probate tax, it's on fair market value, not cost. They don't care about taxes. The only caveat I'll add is it's only Ontario real estate. So real estate outside of Ontario is not subject to Ontario probate tax. And the only thing you can deduct is a registered mortgage. So when you're figuring out your number, that's what to do. So with that said, probate, and I think Ali described it perfectly effectively. It's taking a will to court and having the court hand back a piece of paper that says, yep, this person passed away and this is the person who you can deal with. And I kind of call it, it's not an optional tax, but it's only required if a third party asks for it. So no one is forcing you as a consequence of death to go and get probate. Probate is required when a third party asks for it. And as a general statement, a third party will ask for it if you own real estate in your personal name and only in your name. So not jointly, but only in your name in Ontario. If you have large non-registered accounts that are, again, personally held, not in a corporation and not in a registered investment. And if you have large bank accounts, and kind of the general number is $50,000. So if you have anything more than $50,000 sitting there, probate will be paid. If you own it jointly with a spouse, it passes to the spouse in the first instance, and then probate would be payable on the second. And again, financial institutions and land titles is going to demand probate. Shares in a private company, however, unless other shareholders are demanding probate, it's not technically required because no one's asked for it. Now, if you have shares in a private company and a house in your name as an example, and you have one will, the rule is as soon as one asset needs probate in order to be dealt with, you have to pay probate fees on all of the assets that fall under that will. So a very common planning technique in Ontario is to say, okay, I'm going to have, instead of one will, two wills. And I'm going to have one will that deals, we call it the primary will, that deals with my assets that are going to require probate. Then I'm going to have a secondary will that pretty much looks exactly like my first will, but it's going to deal with the shares in my company, for example. And so when that primary will goes for probate, you do not have to pay probate tax on the assets that fall under the second will. So the shares in the company are no longer subject to probate tax. That is one of the planning techniques in terms of probate. But if you have shares in a private company, you should have a primary, secondary will. The incremental cost of having the dual wills, again, if you're going to someone who does this, is minuscule compared to the probate fees you're going to save. When it comes to probate savings, I will just also say, one of the other things about probate is in Toronto right now, it's taking 8 months to get, maybe 9. So that, and the consequence of that is that the banks will freeze the accounts and you can't sell the real estate. So the money is really tied up and the assets are stuck until probate is obtained. So that's another kind of consequence of probate that we're dealing with right now in the city of Toronto.
Marni, I want to even elaborate on that point, just from the practical perspective. It's a real problem. Like, we have clients whose parents are passing away and you cannot administer the estate, you cannot deal with the assets, you cannot access the funds, you cannot sell the properties until probate is obtained. And so where you might think, okay, it's going to take 9 months to get probate, it holds up the processing of that will for such an extensive amount of time. It's incredibly frustrating. And I have seen some clients, Marni, I think you and I even had one where they had a small amount of assets that were sitting in a primary will, and they may even forgo the assets, just the complexity and the time of dealing with the probate. I mean, it really depends. It's not usual that you would see someone who is just willing to walk away from assets to say, fine, I don't want to have to go through it. I don't want to pay the probate fees. But it's a real burden right now, the length of time. And, beneficiaries might think they want access to their money or to their inheritances. Can't happen until that probate's gotten.
Well, and you can't even fund the income tax is one of the other problems if there's no money sitting there. A couple of things, so that's one way to minimize probate fees, and that's a very simple way, right? Any lawyer who does this and who specializes in it can do a primary, secondary will. There are more creative ways where we continue to kind of roll out the savings. So the first, and I see a question that came in about avoiding probate on TFSAs and life insurance. So for registered accounts, so TFSAs are RRSPs, you're able to do a direct designation and name a beneficiary. So if you name anyone other than the estate, that beneficiary will receive the proceeds outright, and they will not be subject to probate fees. So that is on life insurance proceeds and on registered accounts. The one caveat I'm going to give you about the RRSP or RIF designation, to the extent it's not going to a spouse, just be careful about your designation, because there's a bit of a mismatch in income tax there. Because for an RRSP, if you name your daughter, for example, they will get the fair market value of the RRSP, but there's a corresponding tax that will be payable by the estate. So if your daughter's getting the RRSP and she's the only beneficiary of your estate, there's no big deal there. It doesn't really matter. But and this is something I see a lot in second marriages, where the second spouse may be getting the RRSP. They may not choose to get a rollover. It's quite possible they don't have to. And then the estate and the other beneficiaries have to fund the tax. So just be careful about those designations. Don't do them without advice from either your financial advisor or your lawyer. But that is a way to minimize probate fees.
Marni, I do want to ask again, I don't know if you mentioned it, maybe it slipped my attention from
That's
it.
okay.
So is there a certain dollar value that someone should be worth to consider this strategy of dual wills?
So in my opinion, if you have shares in a private company that have any value, the incremental cost of doing this isn't huge. It's really just paying your lawyer to give you 2 wills instead of 1. At our firm, we do them often enough that I actually don't generally quote much differently between the 2, because it's just so common and simple to do when you're doing it all the time. And you're already filing a tax return for the corporation. Like, we're not creating any additional work. I don't know if we want to get into other forms of probate planning now or not, but there's this whole world of and I saw a question quickly come in about bare trust and alter ego trust and joint partner trust. And those are trusts that also minimize probate fees. That's one of the main reasons to do any of those. And just very high level, joint partner trust, alter ego trust are created under the Income Tax Act. If you're over 65, you have the ability to roll your assets into a trust like that. It lasts for a really long time. You get all the income and capital during your lifetime. It's a beautiful thing. When you pass away, no probate. Okay, that's one. New tax return. So, right, you got it. All of a sudden, you have a new tax return. You have a bit more complicated plan. It may require more fees on an annual basis. Bare trust planning, we do also. Ali, maybe you want to get into bare trust planning, since I feel like I've been talking a lot.
I think it may come up after. There's one other question that came through just before we change gears.
Okay.
There's a good question. It says, does that mean that without probate, you cannot run a company of which there are shares that were owned on death? So that's a good question. So if somebody dies and they own shares of a company, can the company not be run on death? The answer is no. Of course, the company can still run. Usually there's a new director. New directors and officers would be appointed to the corporation, and the company can still continue and carry on its day-to-day activities. The bigger issue we see is usually when you have to go to the bank and say, okay, release the funds or transfer the assets, and the bank won't release the funds, but we'll keep going. So Mickey, why don't you go ahead?
Okay. For my next question, we have so many questions coming in, so it's really hard to navigate with all of them. But Ali, I do have a question for you. And it's very common here in Toronto, and I'm sure all over Canada. Many people have children and grandchildren that are Americans. Either they live in the US or they're married into a US citizen and have children or grandchildren that are American. The US tax is very scary, and a lot of people are talking about it all the time. So is there a way that you can plan it to reduce the impact of future generations?
Sure. So that is a great question. So number one, I will say it is rare these days to find a family that doesn't have an American child or grandchild somewhere in the mix. Sometimes people realize that they themselves are American because their parents were born in the States and they didn't know, or they didn't realize, or they forgot. But so what we're talking about here is, I'm not specifically talking about when the parent passes away and leaves us. I'm not talking about the tax at the time of the parent or grandparent passing away. We're talking specifically about if someone has a child or a grandchild who is an American, and if there is a lot of wealth in the family, significant, tens of millions, hundreds of millions, Is there planning involved? Let me go back. If no planning is involved, if that person leaves $50 million, I'll pick a number, $50 million to their child, who is a US citizen, regardless of where they live, but is a US citizen, what happens is that child has now inherited $50 million. And when that child passes away, if they still have that $50 million, they will have to pay 40% tax based on today's rates to the IRS, which is ludicrous because you're like, this money came from Canada, it has nothing to do with the US. Why is the IRS charging this tax? So what is often done is that in a Canadian's will, when they're leaving money to people who are American citizens, or green card holders, I get, but let's not worry about the green card holders. But when you're leaving money to your children who are American citizens, or if your Canadian child has married an American citizen and your grandchildren, by virtue of your in-law child's citizenship, are American citizens, often, I won't get into the specific details, but often what happens is that the Canadian will leave assets to that child, but really through a special type of trust. And the child still has access to the money. They can still use the money within that trust, but it's left to a special type of trust so that on the death of the child or the death of the grandchild, which of course should be many, many, many years from now, but it will escape the US estate tax net. So if you're part of a family that is very high net worth, where you're going to be leaving money down a chain and there are Americans in the picture, you have to make sure that you have this type of, it's just some certain special language. Marni can tell you really what will happen is your Canadian lawyer will converse with an American attorney to make sure that the right language is in your will, to have the flexibility to create this special type of trust that only comes into existence when you die. And really, it's not to help your child, because remember, when your child gets it, they'll get the full $50 million. It's to help the future generations so that the money you're leaving them isn't subject to this 40% tax right off the top. Okay.
And if I can just add in, when we're creating those trusts, which we do often, your child will have a lot of flexibility because generally speaking, we appoint your child as a trustee of their own trust, and we appoint your child and their children as beneficiaries. So, and generally speaking, they can make unlimited distributions for its health, education, maintenance, or support. And every time I talk to US counsel, they're like, that's everything. Like the terms are so broadly defined that you don't need to be worried about putting undue pressure on your child or them not having access to the money. It really is just on the US estate tax side, so that the money can continue down for generations, as Ali said. And again, there's enough flexibility there that if something happens in the US and plans change, they would be able to get the money out over a few years. So it's not like you've tied their hands forever. It's just a planning technique that we put in place to help.
And something, Marni, that you and I have often discussed with our clients as well. I'll often have a client come to me and say, Ali, I'm going to go see my lawyer to create my will. My child's an American, or all my children are American, whatever the story is. I'm worth, let's say, $20 million. I have 3 kids. I look at them and I say, I do the rough math and I say, okay, you're going to leave each kid around $6.5 million. Hopefully I got my math sort of right. You're going to leave each kid $6.5 million. Don't bother doing anything. The reason why, I'm not trying to be flippant about it or make them feel badly that they don't have enough wealth. The reason why is, remember, chances are that child, if those are the dollars we're talking about, chances are that child is going to use that money during their lifetime. There's no magic to the number that I mentioned there at 20 million. It's not like, oh, forget it, I'm in the clear, don't have to worry. There's no magic to the number. I just find that sometimes people get very hyper or overly excited about it, and they start to create very complex structures. When you have to recognize, if you're young enough and your children are young enough, depending on the quantum of the dollars, maybe young enough isn't the right term, but remember that, it's how much money is going to be left over at the time of death of the child. And if chances are they're going to spend it, there's no planning that needs to be done because there's going to be nothing left for the tax man in the States to take away.
Another reason to, big changes in tax, back to when should you change your will? If Biden lowers the number to $3.5 million, people should maybe change their wills. But again, to Ali's point, you plan for the day. You don't plan for the future, like knowing what the tax regime is going to be, because it changes so frequently. But again, just to keep your ear to the ground.
So I want to move on to the next question.
Okay.
that takes in consideration children, because I'm getting a lot of questions on the Q&A, and we have also a question like that before. So what is, if someone is preparing their will and is concerned that their child's marriage may not last, is there a way to someone to leave assets to their children in a way that is protected from a future divorce? I think a lot of people ask that question. So
yeah, that's a very common, very common concern. Even when they love the daughter-in-law or son-in-law, it's a fair concern. So I will tell you just from first principles, in Ontario, family law says that inheritances and gifts received after marriage are protected from a divorce if they are kept separate and apart and they are not put into the matrimonial home. Okay, if they're put into a matrimonial home, absent a marriage contract, a properly enforceable mortgage, that protection is lost. But as a general statement, those are protected in the event of a divorce. So when parents are giving their kids money, even during lifetime, I will say put it in a different, have them tell your kid they put it in a different bank account. If they want to use it to pay for a trip, they want to use it for certain things, that's fine. But they really need to keep it separate and apart. And they should also be careful about not starting to use it to pay the mortgage every month, not to have it form part of their ongoing everyday expenses, because on a divorce that could play into support. When it comes to inheritances, as I said, if they're received after marriage, not only, again, if the will's drafted properly, and I would say that any practitioner in this area would draft it properly. If an inheritance is received after marriage, and if there's a special clause in the will, not only is the capital protected, but any future growth associated with that inheritance is protected as well. So you put in a clause that really says, I'm giving my kid this money, and it's my intention that not only this money, but any future growth in the money is protected from an ultimate family law dispute. Now, one thing that I find parents do to take it one step further, and it actually helps their kids from a tax perspective, is sometimes instead of giving a child a gift outright in the will, even if the child's old, right? Like the child's 35, 40, they're fine, they're successful, they've got kids, all is well. And even if they don't necessarily have any concerns about the marriage, something that I find clients are doing is instead of leaving the asset to their child, they're putting it in a trust for their child in the will. They're putting their child, again, as a trustee of that trust. So the child's in charge, and they're making the child and the grandkids beneficiaries of that trust. And the benefit to that structure, A, it's separate and apart. It is in a very different structure. It's not in the child's name. And secondly, it presents some income splitting opportunities for the children, because all of a sudden mom, who's the trustee of the trust, if it's a daughter, can pay for, school or camp and allocate some money out to the kids and use their graduated rate. That type of income splitting is allowed. So I do find that sometimes that's a plan that parents put in place, and it kind of has the dual benefit of keeping the asset really separate and, again, a bit of a tax play. Again, I put in the flexibility to say, if my kid wants to take out all the money on day 2, they have the ability to unwind the structure. So it's really just about, again, giving your child a tool that they can choose to use or not use. It's up to them.
Thank you, Marni. So let's continue with family issues again. This is a question for you. We have many clients that are bundled family, where each spouse brings children from previous relationship to their marriage. What are some considerations that these types of families have to consider when considering their estate planning? I think this is another question that came up a lot during the Q&A, so happy to hear your thoughts about that.
Sure, I'll take it first, and then Marni's going to be the expert, certainly on the legal side. So blended families, so there's no perfect answer here, and it's an art form, not a science. Marni, I think you'd agree with that.
Yeah.
It purely, and every single family is going to be different. Every family is going to be different. Every blended family is going to be different. And the reason why it's so important, or the things to think about, or what I've seen, is that some people come to the second marriage and say, I'm coming to this marriage, I have my children, you have your children. We're going to use our assets together, but when I pass away, Some people say, I want my assets to go directly to my children only. Some people say, you spouse can use my assets while you're alive, but when you die, whatever's left over is going specifically to my children, not to your children. Some people say, no, it'll go equally to all of the children. You know, I'm treating everybody equally. It's not uncommon, though, for people to do one of the first two, where they either quote unquote take care of their spouse, especially if you have a situation of one wealthy person coming into a second marriage and one person who has less assets coming into a second marriage. Often what will happen is there's concern that the spouse who has the money wants to make sure that that money gets left to the children, and they don't want their second marriage spouse to, you know, if they should die, to run off with it and spend it all or leave nothing behind. So there's anything, I'd say anything is possible to a degree. Again, it really depends on the relationship of the blended family, if you will, and we've seen all kinds, and it's all okay. It's just important that you communicate with the person who's preparing the will to make sure that the funds are going to fall out of the will of your estate in the way that you want them to. It may not be the most, in these circumstances, to some degree, you might throw tax out the window. You might say, look, I don't care if there's a tax savings of having it transferred to my spouse without tax. I know there's going to be tax sooner than there would have to be if it just goes to my kids, but I want my kids to have it. There's all sorts of ways of doing it. In certain circumstances, the one thing I would caution against is that when people try to quote unquote marry their spouse from a second marriage to their children from the first marriage, that's usually not great. Like sometimes the structures become so complex that, you know, we're forcing people to have these assets that are co-owned in certain ways. I like to keep things simple and clean, if you will. Yeah, so I would say, again, it's an art, not a science. Every family is different. Anything can be done, but certainly these are some of the traditional ways that we've seen people approach this.
And so in terms of the art form, just a couple of things, if there's any blended families out there that I think are important to talk about with your estate planner. One is, how are the assets held? And truly understanding what owning an asset jointly or individually, or as something we call tenants in common when it comes to real estate is. Those nuances are key, because oftentimes I'll find spouses will come in and say, we own the, you know, and take a marriage where, you know, there was a first marriage, there was a child, you know, early on in life, there's a second marriage, there's children of the second marriage has been going on for 30 plus years, right? Like but there is a child from a previous relationship. So that second marriage, that second family unit, it's not uncommon for assets to be held jointly. It's not uncommon for that to make sense, but you really have to understand what that means. So, you know, if you own an asset jointly and you pass away, that goes to the other spouse. And if that other spouse is not the parent of that child from the previous relationship, you have to accept that regardless as to your wishes and regardless as to what your spouse tells you they're going to do, that could change. And you either have to let it go or you have to do something about it. And there are lots of ways to do something about it. You can, you know, leave them a different asset. One thing that I find in those types of situations, especially depending on who brought the wealth or how it's happened, is I will leave, because Ali talks about marrying, you know, a step parent to another child. And that really means making them wait for their inheritance until their step parent passes away. It's never a good idea. So in those circumstances where it is, no, I want to take care of my spouse, I think that's important. And my kids can inherit when she's gone, when he or she's gone. Something that I'll often do is I'll carve out a number for an inheritance, a legacy number for the child who's now waiting. So they're not waiting for their step parent to pass away. They're actually getting something in the first instance when their parent passes away. So there's something tangible there. It's just one little thing that sometimes softens the burden or the blow of having to wait for your inheritance until a step parent passes away. But I find the real estate is the trickiest one, because oftentimes they went to a real estate lawyer and they bought a house and they own it jointly, and they don't know what that means. When you go, okay, well, if you pass away and it goes to your husband can turn around and give it to his kids, and that just is what it is.
Or his
And-
new wife.
Or is it right? Or whomever, right? And you know, I've been a litigator. I don't do it anymore, but I've seen the best of families go terrible. So, you know, I'm a big proponent of let's plan for the worst when things are good. Let's get it all out on the table and let's all come up with a solution. And this happens in all families, right? So when you couch it that way, it's a lot easier to digest than this is about you, parent, or this is about you and your relationship with the kids. I'm of the view that the best families can go bad. So I give the same advice regardless as to whether or not they say I have a great relationship with my stepkid or I have a terrible relationship. Like it's all fair game.
Well, I see that you managed to see a lot of different situation in your career. So this is talking from
Keeps me on my
experience.
toes.
Yeah. Okay. So another question, Marni, that came up a lot is what should someone consider when a friend or a cousin asks them to be a trustee of their will? What are the responsibility for being an estate trustee of a will? And if I might add, my personal question that I asked you before we started this webinar, what's the difference between a trustee and executor? Is there a difference?
Right. So the first thing that I'll say is you're lucky if someone asked you, because oftentimes it just falls into your lap and you didn't know it was coming. And as a general statement, I would say no. It's a lot of work. So people often conflate, and let's start with the executor versus trustee concept. An executor is the person who's named under the will, who's gonna, when someone passes away, take charge of the assets and administer the estate. They're gonna apply for probate. They're going to pay income tax. They're going to clean out the house. They're going to advertise for creditors. They're gonna cancel the credit card. They're gonna pay off the bills. They're gonna sell the house. They're going to do everything that needs to be done in order to quote unquote wrap up the estate. And that job can take, depending if there's a company, and we didn't get into how long that can take, but that job can take up to 3 years to do. So it's a big job. That's the executor. The trustee generally steps in if, when the estate is done, it's not just give everything to my kids, if there's trust created. And sometimes the executor is the same person as the trustee. Sometimes it's someone different. So there's a bit of a distinction between executor and trustee. So that's kind of the starting place. When it comes to the rules, like the responsibilities, I just kind of listed out some of the administrative tasks, but there's serious fiduciary duties. So what are you going to sell the house for, right? What's the best price? When are you going to, one thing that I find executors are struggling with right now is investment portfolios, given the volatility. People are afraid, do I keep the investment portfolio? Do I sell it? Because with being a trustee, you're a fiduciary and comes personal liability. So I find that executors are quite concerned right now, and particularly add in the complication that in Toronto, if you have to apply for probate, it could take 8 to 9 months and your hands are a bit tied, right? And you're sitting on real estate or you're sitting on an investment portfolio, and the investment advisors generally won't take instruction on trading until you have probate. So there are a lot of headaches. Someone could leave their estate a total disaster with back taxes, non-compliance when it comes to corporations, outstanding lawsuits. So sometimes it's really simple and it's my mom's estate and all she had was a house and I'm the only beneficiary. Of course, it's going to be me. But to the extent it's an unknown, it's an individual that, it's a sibling, maybe they don't have their affairs totally in order. There's a lot of work. If there's trust to be administered under the will, be it for minor children, or for disabled children, or for children who are facing some sort of hardship where you've created a trust, be it drug dependency, mental health concerns. I think in those cases, I'll often recommend, particularly when it's a trust that has to last for the rest of the person's life, in all likelihood, a trust company. So there are professional trust companies that do the job and who get paid to do the job, but are professionals at this. And they will take the reins and do the work. and invest and take on the liability if something goes wrong. So in the right circumstance, I am a fan of speaking with trust companies and trying to get them involved where appropriate. I also am a fan of doing a trust company with an individual, because I find the individual will bring the personal touch to the file. They know the person, they have a connection with the beneficiaries. Not all trust companies are created equal. I'm not going to speak to which ones are on which scale. But, some trust companies have people circle through, and your trust advisor is not always going to be the same person. And it is a large financial institution. So I do like kind of adding two people together. It takes some of the burden off the individual, but it keeps, someone who's personally vested in it on top of the trust company. So I do think the two can work hand in hand quite nicely. But I can tell you, being an executor is a burden, not an honor, is my general statement on that. It is a burden, not an honor.
That's why when you started out saying, if someone asks you, it's an honor, and I'm like, no, it's actually a ton.
No. I meant you should be grateful that they asked, because normally they don't ask, they just name you, and then you're stuck with it.
You have the opportunity to say no.
Yes, exactly.
But usually, should it be someone that close to you, a family member, like for an executor, or do you think?
It can be. It can be an executor. It can be a family member for sure. But sometimes sometimes it's a friend who's not necessarily beneficially interested in the estate. And sometimes for a variety of reasons, it's a third party. It's a corporate trustee, it's somebody who acts as an estate trustee as a full-time job. Again, they get paid to do it, but it's a huge burden and they take it on. And sometimes the family will say, no, we don't want to take on this job. Let's have the corporate estate trustee come in and do that. And, we're happy to pay for the work. So there's no one that it has to be. I saw a question come in, is there a certain number? I would think in the world of the estate, there isn't a certain number of trustees. You could have one, you could have more. I would caution against having too many, because then it can become a little bit burdensome. I would caution against, if all of your children live in the States, physically reside there, give someone a call, because you don't necessarily, if you have the majority of your trustees live out of country, technically your estate will become a non-resident estate. That might be a great reason to use a corporate trustee resident in Canada to manage the estate so that it remains a Canadian estate. Yeah.
I would also caution against two sometimes, because that means unanimity. So when people have two, I always ask about the relationship and say, it means unanimity unless you give someone a veto, or unless you have like someone coming in as a tiebreaker.
Right.
Just something to think about when people are appointing two people.
Okay. I wanted to ask another question that came in a chat with regards to children with special needs. Is there any specific thing that they need to do when they're writing their will, or to appoint anyone in order to take care of it? And what are the legal circumstances that they need to consider?
Okay, I can grab this one. So I guess the first concept that people often talk about when it comes to planning for kids with disability, or the first question I'll ask, is whether the child is on ODSP, Ontario Support Disability Payments. I think I don't know the words, but ODSP. And to the extent they're on ODSP, there's very stringent requirements about what a child can own. And what type of assets they can have before they'll be disqualified from ODSP. And so as a common planning technique is called what we call a Henson trust. And so in the will, as opposed to leaving the money to your child outright, you would put it into a Henson trust, which effectively has them as the beneficiary of the trust. You put someone else in charge. They get income and capital as the trustee sees fit to help for their needs, but it's drafted in such a way that it won't put them offside ODSP. So they will continue to get the payments from ODSP while having the inheritance. And the ODSP payment isn't huge, and that's generally not a reason to do a Henson trust. But the supports that come with ODSP and the drug plans And all of the additional things that you get other than the monthly check are often a reason to try and stay on ODSP. So that's if a child's on ODSP. To the extent a child's not on ODSP, you know, again, a trust structure in the will, if you don't want your child to get it outright, is, you know, you can still do a Henson type trust, discretionary, pay for them, help them, you know, supports. And I spend a lot of time with clients talking through, you know, what they should do with children under disability. But again, a trust structure. And again, to the extent you think this trust is going to last a long time, there has to be very careful consideration as to who the trustees of that trust are going to be.
Okay, so we're 8:57. We're almost 9 o'clock. So let's take a very short last question, and then we can continue after that on the chat or after the event is ended.
There's so many good questions still.
Yeah, there are a lot of good questions. So I tried to pick the very short one. So there is someone that has a will that was created in Quebec. Does it matter? Does it change whether the person lives in Ontario and created a will in Ontario? Is it everything in Canada is the same, or it depends on the province?
So Quebec is civil law, so it's a different type of law. There are notarial wills in Quebec, so they're quite different. It would still be a valid will, but to the extent that the person who has a will is a resident of Ontario and has Ontario assets, I wouldn't rely on a notarial will. To the extent there's a connection to Quebec, a notarial will can be a good thing. But if you just happen to be going to school there, for example, and got your will done, but you're really a resident of Ontario with Ontario assets, I think it would be important to talk to an Ontario lawyer as well to make sure you have the right plan in place. Other provinces, I would say, is probably okay, but Quebec is civil law and more common law.
Wonderful. Ali, are there any aspect from a tax point of view if you are living a different
No,
province?
there's no tax aspect point of view. I just wanted to remind people that although we're going to officially have the last question out, Marni and I and Mickey are happy to stay on and continue going through the questions in the chat. There's lots of great questions here, and we'll continue going through them. So you don't have to walk away if you don't want to.
Wonderful. So thank you, Ali and Marni, for this insightful and informative discussion. Our official program, as we said, is about to conclude, but as a special opportunity, our panelists have offered to stay on the call after the conclusion to answer any question we weren't able to get to and continue to do a conversation. Please feel free to stay on the webinar if you would like to. Now over to you, Melissa, to close out the official part of the program. Thank you, everyone. It was really good.
Thank you so much, Mickey, for moderating tonight, and Ali and Marni, once again, for such an informative session. As Mickey mentioned, I'm Melissa Muskat, Chair of Women's Philanthropy for UJA 2020 Annual Campaign. At the beginning of the program, Leah Silber mentioned how far we have come in the UJA 2020 campaign to meet the increased needs in our community due to the pandemic. She is correct when she said we also still have a significant way to go. I cannot stress enough how the next coming months are going to be critical for our community's most fragile members. The needs are not waning. It is through the social service agencies and partners supported by UJA that we can help those desperately suffering from food insecurity, those in need of mental health and addiction supports, and those who need to find a job during these troubling times. The community needs us now more than ever. Once again, please reach out to UJA to make your gift if you haven't done so. We thank you from the bottom of our hearts. And thank you again to our incredibly dedicated sponsors, Erdem Berlis, Baskin Wealth Management, BMO Financial Group, and Crow Soberman. This brings us to the end of our official webinar. If you want to stay on for the after party, please do, and hopefully all questions can be addressed. Please stay tuned for the next webinar in this series entitled Understanding Financial Statements, which will take place on December 2nd at 8 p.m. Thank you all so much and have a wonderful week.
Thank you so much, Melissa.
Thank you.
Okay, so there's some great questions here, and I think what we'll do is I'm gonna read this one out loud. I hope that you can see me. Oh, there we go, back to gallery view. Okay, so this was a great question. I'm going to read it word for word. It said, the process of estate and family tax planning is complex with wills, accountants, financial planners, insurance. Where does one start? Is there a recommended protocol to get through the process? Which professional should take ownership to guide the process along to completion? Well, of course, it's the accountant. I'm totally joking. I'm just saying that because I'm the accountant. It's a beautiful question. It's important. And I think truly it's a holistic approach. I think that everyone, and part of the reason why we have Mickey here, who comes from the wealth management side, Marni, who's the lawyer, myself, who's the accountant, is to show you that it really, I know it sounds so cheesy, but it is a holistic approach where it's cheesy or holistic. We'll go with holistic.
It's both. No.
You need all of your professionals together, working together towards a common goal. And it's important that no one should be doing part of it without informing the others. Often what will happen is, even if parts of the discussion happen with just the lawyer or just the accountant or just the wealth manager, it's important that the team comes together at some point just to have a state of the union and make sure that everyone's on the same page. I'll often say, okay, I don't need to be at your will drafting meeting, but I definitely want to read a copy of the wills before you sign them, just to make sure that they're complementary to what I believe you want your estate to look like and how it's going to be. So it's very common for the team to work together. For sure, I think and of course, insurance plays a part of that as well to provide liquidity for the estate in certain circumstances. It's never the same group twice, and it's never the same ingredients twice in the cake, if you will, meaning that sometimes it might be the lawyer who takes the lead. It could be the wealth manager. It doesn't matter as long as the group is working together as a whole.
Great point. I totally agree. I love it when Allie takes charge of a file. It's awesome. I always know it's going to get done. I see a lot coming through or has come through about minimizing probate fees and owning assets with kids, or mom's around and there's a kid with real estate, and how do we minimize probate fees? How do we get out of this terrible probate world? And so there are lots of ways to minimize probate fees when it comes to real estate. And every situation is different. I want to be very, very clear about that. I don't think one size fits all when it comes to it, but a couple of structures that you could speak to a lawyer about is, one, you can own an asset jointly with a child. I don't love that plan, depending on the family. But you can, put your child on the house as a joint tenant. Whenever I do that type of planning for clients, I have an additional document that's called a declaration of trust, whereby the child confirms that they're only holding the asset on behalf of mom and effectively for convenience purposes, and that it is still mom or dad's asset. The consequence of that is that on title, it shows up as joint tenants. So when mom passes away, title can be dealt with just a death certificate, and probate is not required. I'm going to caution strongly on this one. To the extent you do this, and there's only one will, okay? Only one will. We didn't do the dual will structure. If there's any other asset that will require probate, so a bank account that pushes it into probate, the plan fails, and the real estate, even though land titles is no longer asking for probate fees will still be payable. And why, you may ask? Well, when you apply for probate, the executor has to swear an affidavit. The affidavit says, I have listed all of the assets that fall under this will. Well, to the extent you were only on title as a convenience, and you were only holding it as bare trustee, well, that asset forms part of mom's estate. And I don't know an executor who would be prepared to swear the affidavit without including that asset in the probate calculation. So I caution against the plan not being done properly and with proper legal advice to either ensure that all assets are held jointly, or that a primary secondary will is put in place, where the secondary will deals with what I call assets held in trust, so that house still forms part of mom's estate, but it goes into the non-probated will. So again, it's planning that can work. It's also planning that's right for litigation if there's more than one kid and they're not all on title. So as I said, every family is different. It's not one size fits all. But if it's done, it's a bit more nuanced than I think people appreciate. But it is possible. The other planning is a bit more complicated, where we incorporate a company. The company holds legal title and beneficial ownership stays with mom. Again, because land title sees a company on title, they won't demand probate. Again, if there's only one will and one asset needs probate, probate will be payable. So you need the dual will structure again. And the last one are the alter ego trust and joint partner trusts. You can also do those and avail yourselves of those under the Income Tax Act to avoid probate. So there are ways to do it. Talk to a professional. Doesn't cost a ton. It can be done, but it just has to be done properly. And that's why don't go to your real estate lawyer to get this type of planning done.
There's one thing that I wanted to mention. It's come up a couple times in the questions. And I'm going to put it out there. It's a huge topic and it may blow some of your minds. I'm just going to mention it. I'm not going to get into the detail. If somebody dies owning shares of a private corporation, I just want you to be aware that without special planning that must happen within the first year after the person passes away, you may have double taxation on the death of the person who died. And what I mean by that is that consider someone, so again, it's only applicable to people who own assets inside a private company, okay? So I want you to just think about, if you have, let's say you have an investment portfolio, for whatever reason, it started worth $1 and it grew to $100. And there's a $99 gain within the value of the assets in the company. That same gain is sitting in the shares of the company as well. And as I mentioned way back at the beginning, when we die, we're deemed to dispose of the assets that we own personally. In this case, we have tax once when we're deemed, we don't actually sell the shares of our company, we're deemed to dispose of the shares of our company and pay tax on that capital gain. But without careful planning, there could be a second level of tax when the assets that are sold within the company are sold at the same $99 gain in two different places. And those assets are sold and the funds are distributed. So I just want to put it out there. Sometimes people are absolutely shocked. They come to me, they say, oh, I met with Marni. She's going to administer mom's will. And we noticed that mom owns a real estate property inside of a corporation. And Marni said, it's very important that we come speak to you right away. How come? And I say, yes. And I explain that if you do nothing, that 25% tax you just paid on mom's death is going to go to 50%, or even worse, could go to 65 if you have to pay a dividend tax and a gains tax. It's way beyond the scope of this discussion to get into the techniques that we use to eliminate the instance of double taxation. But what is key is the time. There's two typical techniques that we use, which is where I spend a lot of my time in my day life when I'm not speaking on webinars. I spend lots of my time helping clients come up with plans of how to work with those assets so we don't have double taxation. But again, there's two ways. One is important because in certain circumstances, it must be done within the first 365 days of the person's death. And if it's not, it's too late, too bad, so sad, you're stuck with the other one. And in many cases, it's not necessarily the best tax result. So I just want to put it out there. If somebody dies owning shares of a private company, you got to get to the lawyer and accountant right away and say, what do I have to do? Ali Spinner said, I got to be careful. And they'll be happy to walk you through what's got to be done there.
Sorry, I'm running through the questions because they're so good. One question that was asked early on in the presentation has to do with, and there's this concept out there about leaving, $1 to a kid you want to disinherit, because then they're in the will and, they can't say that it was a mistake and you didn't think about them. And I want to caution against that. As a general statement, if my client comes to me and wants to disinherit, I can promise you I'm having 2 or 3 meetings with them, maybe more. I'm taking copious notes about the reason behind the disinheritance. I'm being very specific about it. I'm often bringing in either an articling student or an associate to participate in the conversation as well. So anyone can challenge a will. Generally speaking, challenges are undue influence, incapacity, Those are really the two big ones, or they didn't know what they were doing. So I'm against that type of planning. I don't think you need to put them in. I'd prefer to put in a line that says I'm consciously not leaving them anything and acknowledging it. The dollar doesn't do much. Again, anyone can contest a will. So I just wanted to put that out there. That's where the value of going to someone who's going to take the time to have a conversation with you about it really, really comes into play. One other question I just want to get to, because I think it's been asked 4 times. You do not have to give your kids their inheritance all in one chunk, even if they're Canadian. I pretty much always do trusts. So either there's that lifetime trust that I talked about from an income splitting perspective, or, you say, and I spent a lot of time talking to clients about this, my kid's 20, I don't think they should get all this money. It's $2 million. It's too much at 20. And we do, I'm a big fan of staged distributions. So, a portion at 20, a portion at 25, the rest at 30, maybe they'll blow a bit, then they get a little bit more. Then they can figure out how quickly $500,000 can go, because if you're not being careful, it can go faster than you may think after taxes and buying things and the vacations. So you absolutely can. The only thing that you have to keep in mind in Ontario is trust can only last for 21 years before there's a tax hit. So, and that's 21 years from the date of your death. So you don't really have to worry about it, but that's a number that generally we don't go past when it comes to these types of trusts.
Okay, there was an awesome question here that I'm going to answer. And I think the person thinks it's a surprising question, but it's not. And they said, are there family marriage psychologists that specialize in the emotional issues in estate planning with spouses that differ in opinion and planning? And I think they think that it's unique, as they say, I'm not kidding. So first of all, it's very common that different spouses have different, want to leave things in different ways. Some want to be more charitable than the other. Some want to leave to the kids or not. Some want to cut a kid out of the will. Some don't. There are absolutely, and I would say it even goes beyond this. I would say it's the concept of difficult conversations with families. So I'll just put it under that umbrella. I know a number of professionals. If you need a referral to one, I'm happy to suggest some of them to you. They're excellent. And they will work through these issues with the family when it comes to the discussions and enable the family to have the difficult conversation and get through it together and hopefully come to a resolution that works for everybody. I don't think it's a silly question. I think it's a very valid question. I think it's actually unrealistic to think that everyone's going to be on the same page about how it goes. Marni, I'm sure in your meetings with spouses, you start to see some sparks fly with respect to I didn't want that money to go there. What do you mean? What do you mean you want to give $50,000 to your sister? I don't want to give anything to your sister. She didn't come to Thanksgiving last year, whatever the reason may be. But it's not unusual. There are absolutely professionals out there who specialize in this type of work. If whoever it was, if you'd like to know who it was, I'm happy to send you an email with some people who do this full time.
I wanted to ask another question that we addressed before. It was about a lot of people have children in the US, and we addressed that portion. What about Israel? We have a lot of families over here that their children live in Israel. Mm-hmm. Is there any difference between US and Israel with regards to taxes and probate?
So that's a great question. So one question I get all the time, and I'm going to use Israel or really any other country, including the States. If you're leaving money to a beneficiary outside of Canada, there's generally no issue. There's generally no withholding tax. There's no gift tax. There's no tax that has to be paid on that $1 million leaving Canada, going to Israel. It's not an issue whatsoever. The only thing that I will mention is that just something to keep in the back of your mind, if the Canadian estate is made up of more than half of it from Canadian real estate, there's a certain form that it's just paper. We have to go ahead and have a clearance certificate filed with the Canada Revenue Agency because the estate is considered taxable Canadian property. There's no tax, but generally we have to have these forms filed with the government to basically say, there's money leaving the Canadian system with respect to this estate, which constitutes taxable Canadian property. Again, the definition is if more than half of the value of the estate was derived from Canadian real estate, There's no tax. It's simply a form that has to get filed. And often what we'll do is if we're going to make interim distributions to a non-resident, we'll kind of present a schedule to the government to say, these are the distributions, or this is what's going on, or we'll do one form per year for the person to be able to make distributions to that non-resident. So it's something to keep in mind if someone has a lot of real estate and they're leaving money to non-residents. But otherwise, no withholding tax. This is, of course, on capital distributions, on money coming out of the capital of the estate to the non-residents.
A lot of people have asked about executors and kids who are not in Canada being executors. As a general statement, it's not ideal. It's not a good idea, both from a tax perspective, in terms of the residency of the estate, but also from a practical perspective. As a general statement, opening bank accounts in the name of the estate with financial institutions with non-resident executors is incredibly difficult. To the extent you need to apply for probate and the executor's resident in a non-Commonwealth country, a bond is typically required to be posted with the court, which is expensive and time consuming and quite intrusive to the executor from a financial perspective. So as a general statement, I will avoid it at all costs if I can. And the other question that I just wanted to add, or that I saw asked, executors do get paid. They can choose to take compensation or not. If you don't speak to it in the will itself, there's a tariff that the court imposes that's roughly about 5% of the value of the estate. So it's actually quite high. You can stipulate in the will what you want the compensation to be, but otherwise they'd have to go to court and get permission ultimately, or sign up from all the beneficiaries about the amount of compensation they're gonna take.
And Marni, I think you'd agree in situations where if it's a child administering an estate for their parents, they typically don't charge a fee to do it. They're going to receive the inheritance anyway. If you charge fees, you have to pay tax on those fees. So if you're going to just receive the inheritance anyway, who cares? But generally, I mean, or if the one child feels, you know what, I'm doing all of this work for the benefit of all of my siblings, I want to be paid for it, that can be okay too. But I just wanted to make the point that it's very typical in what I would call these family estates, where it's a child or some children administering the estate on behalf of their siblings, that they don't charge fees. Doesn't mean they don't have to. Perhaps it depends what the will says, but generally they don't.
There was one question, sorry, I want to get to this because I want to make sure I didn't give bad advice, in terms of a child being on title to the principal residence. As long as that declaration of trust that I discussed is prepared, the child isn't the actual owner of the property, so it will not affect the principal residence exemption for mom. So I want to be very clear about that. It's when you actually own an asset as joint tenants that you could be doing some damage to the principal residence exemption. But if you're only on for convenience purposes and the right documentation's there's no concern about either principal residence or land transfer tax on adding. The other thing I'll say is, if it's, let's say it's a cottage example and it's true joint tenancy, because I see people saying, well, what if I just wanted to go to my kid and outside of my will, can't I just add them on? If you add a child on to an asset that has a gain in it, there's tax payable. If you gift it to them at the time you add them, at the time you add them, you cannot gift two children tax-free unless it's cash or after tax dollars. So I just want to be very clear on that. If it's true joint tenancy, there is a tax hit right away.
So I think it's probably time to wrap this up. I think we've answered most of the questions. I will say that I do, some people have asked for contact information. There will be an email that comes out likely tomorrow that includes both a recording of this session as well as all of our contact information. And hopefully there's also going to be a survey for your feedback. Marni and I would love to hear your feedback, as well as if you have any suggestions for future content. We're here to put these sessions on for you, and by all means, if you have any suggestions. And I see some questions coming in now over items that we already covered. So by all means, you can go back and listen to the recording. Mickey, do you want to close us out?
Absolutely. So really exciting. Really, I'm on the wealth management side all the time. So it was fascinating for me. Marni, I'm going to call you for my will. I think we need an update.
Anytime. I'm happy to help.
Yeah, I've learned so much and was not aware of, especially, coming from Israel. It was such a different, way of thinking. So thank you very much. We did have a lot of participants this evening, and I think, the question coming in, we couldn't handle most of them. So, please reach to every one of the panelists for more information. Thank you, Ali and Marni, for joining this evening, and for the
Pleasure.
UJA for supporting it. And see you in the next seminar.